Please be seated. We have two cases on the docket this afternoon. We'll take them in the order that they appear. I advise both appellants that if you want time for rebuttal, to please let me know. But ultimately, you will be responsible because you do have the clock in front of you. Are both sides ready in the first case? You may proceed.
May it please the Court, I'm Ashley Davis, Assistant General Counsel to Secretary Browning. I would like to reserve 3 minutes for rebuttal. The lower court had a duty to resolve every reasonable doubt in favor of the proviso at issue here, and it erred when it failed to adopt the rational interpretation of the statute by 3 different attorneys general that harmonizes the proviso with the Constitution. And for that reason, the lower court's order declaring the proviso unconstitutional should be reversed.
If there are 2 reasonable interpretations of the statute here, are we required to follow the Attorney General?
Your Honor, the Attorney General's opinions are not binding, but this court in Beverly v. Division of Beverages specifically found that when 2 attorneys general reached the same conclusion, that opinion was entitled to more than just great weight. It was entitled to considerable persuasive influence and weighed heavily on the court's decision. Okay,
let's assume there weren't any Attorney General opinions out there. If we find there are 2 reasonable interpretations of the statute, where are we?
Your Honor, if the statute is ambiguous, susceptible to more than one interpretation, then the proviso stands because it doesn't conflict with or change existing law.
What if there was not a statute at all in this particular situation, and the legislature put this language in there in the proviso bill? Where would we be?
If we just had the proviso at issue and no other legislative authority, then the proviso would prevail.
Okay. But the cases don't necessarily say that you have to amend another statute. You just need to amend existing law, correct?
Correct. Under the 2 principles flowing from Article 3, Section 12, the appropriations bill must not change express law on subjects other than appropriations or matters properly related therewith, and a qualification restriction must directly and rationally relate to the purpose of the appropriation.
Under their reading of the statute, they read the statute to say that an agency head may spend public funds to pay for bar dues. Am I correct in that?
You are correct, yes, sir.
Okay, if it clearly said that and says what they say it says, is the proviso unconstitutional?
If it expressly permitted agencies to pay bar dues, then the proviso would still stand because it's still on a subject of appropriations and matters properly related therewith. The proviso is a bar dues benefit, a provision about bar dues benefits, and it is directly and rationally related to precisely on the subject of appropriations for the salaries and benefits of state workers.
Well, what if there was a statute that said attorneys that work for state government shall have their bar dues paid out of appropriations? Would the proviso saying we don't have the money this year, we're not going to pay it, would that be constitutional?
It seems that if there was an express conflict with existing law, that it would fail under Article 3, Section 12. But we're not dealing with anything expressed under the statute.
Okay, let's go to the wording of the statute for a second.
Sure.
And this may not be directly on point of this case, but I'm having trouble with the language that subsection 2.
Yes.
Which starts, except in those instances where agency or branch membership is necessary. I think I understand that. And purchase of an individual membership is more economical. My question to you is, more economical than what? Because it appears that if you go earlier, you're talking about the only time you can do this is when the branch can't buy or an agency can't buy a membership. So what does that language mean?
Sure. Well, The purpose of the statute is to allow agencies to pay the dues of the agency's membership in a certain professional organization. Subsection 2 then provides for some very narrow exceptions. And the way the attorneys generals have interpreted it, and as well as the Secretary adopts those interpretations, is that the two sentences in subsection 2 are separate. The second sentence, which you were reading from, kicks in when the membership dues are to maintain an individual's professional or trade status. In that case, it would be, bar dues would fit under that as being in maintenance of an individual's professional status. In that situation, that second sentence is triggered, and an exception lies where two conditions are met, the two conditions that you just read.
Okay, but I guess what I'm asking is more economical than what?
The agency's membership.
Okay.
Because that second sentence only kicks in when you're talking about maintenance of an individual's professional trade status. And when the two conditions are met, this is for the narrow exception to this prohibition, the purpose of the statute being to provide agencies being able to pay the dues of its membership in organizations.
So clearly the exception, except does not apply here because an agency could not be a member.
Correct, Your Honor, and that is the only interpretation of this statute that is from the Attorney General's opinions that's been consistent throughout the decades.
Okay, what about the portion of the statute? I mean, their argument is this thing about maintaining trade status in any association or organization.
Right.
Goes to things like certification of a specialization. Could you respond specifically to that?
Sure. What is also included is, we would argue, that includes just general membership in the Florida Bar. That's maintenance of an individual's professional status. Certification in a particular section may also be, but we're not dealing with that. We're dealing with just plain Florida Bar membership dues.
Okay, they say their argument is the prohibition only applies to the certification, if I understand their argument correctly.
And their interpretation is counter to the three different attorneys general's opinions that have consistently held that maintenance of an individual's professional status speaks directly to Florida Bar dues.
Okay.
Ms. Davis, you keep talking about these attorney general's opinions as if they were handed down from the mouth or something. Are they anything more than the opinion of whatever staff lawyer wrote it?
Your Honor, respectfully, the decisions of
Well, isn't that how they're done? Doesn't some staff lawyer write these things?
They carry the weight of the Attorney General. The Attorney General
Does the
himself
Attorney General actually read them?
approves them. Yes, sir.
Does he or she actually read them?
Yes, Your Honor.
You're sure of that?
Well, their signature attaches to these opinions.
In all candor, I guess if that's all you got, you ought to argue it. But opinions of the Attorney General really don't carry a lot of water with me.
Well, and Your Honor, they are the only interpretation of the statute. They've maintained consistency over 3 decades.
I guess what I'm telling you is I think probably if you want to convince me, you'd do better arguing statutory construction than you would hanging your hat on Attorney General opinions.
And Judge Webster asked the same question I was going to ask him in a different kind of manner, because you go back to the Attorney General's opinions. Why is your interpretation better than their interpretation?
It's the only interpretation of the statute thus far. And
you're going back to the Attorney General's opinion. Let's let the Attorney General's opinions off the face of the earth.
Okay.
They say this language applies to the certification only. You say it applies to general bar dues. Why is their interpretation wrong and yours right?
Other than because there are Attorney General's opinions out there.
Yes, Your Honor. If the statute is susceptible to more than one interpretation, then the proviso stands. Because under Article 3, Section 12, it has to change existing law. And the proviso that issue in the cited cases in the briefs involved provisos that were in direct contravention of express terms of the statutes. That's not present here.
Okay, so basically your argument is that your interpretation is just as viable as theirs, and that we're required to follow that because that's the way we uphold the constitutionality of the proviso.
Correct. And the lower court was under a duty to adopt any rational interpretation of the statute that would save the proviso by harmonizing it with the Constitution. And it just so happens to be the interpretation that the Secretary adopts, which is the interpretation of 3 different attorneys generals as well.
So you're not arguing that the part that begins, however, approval shall not be granted to pay membership dues for maintenance in an individual's professional trade status, that language doesn't clearly rule out bar dues?
We interpret it as clearly ruling out bar dues, but it certainly isn't a clear express grant of authority for bar dues to be paid, as appellees have argued.
Does it make any difference if at one time some of the state attorneys determined that bar membership was essential to the statutory duties and responsibilities of their office? You can't be an assistant state attorney or an assistant public defender without being a lawyer, so that seems pretty essential. Does that finding make any difference?
Your Honor, that factual determination that it's necessary or essential to be a Florida bar member is irrelevant to the legal determination of whether the statute even grants the authority for agencies to expend those funds. And that factual determination is up to the particular agency according to the specific criteria that are dictated in sub 3 of the statute.
Let's talk about expungement from the record. What does that mean?
And, Your Honor, respectfully, the Secretary rests on his briefs as to the matter of expunction and notes that if the Court finds that the proviso is constitutional, the Court need not reach that issue. But if there are specific questions, I'd be happy.
Well, they recited a bunch of cases that have this shall expunge from the public records of the state. What does the Secretary of State do when that happens?
I'm sorry.
I mean, it seems to me the Secretary of State also has a duty to maintain public records. It can't just disappear as if they no longer existed, can it?
Yes, and as was discussed in the briefs and throughout the record, the Secretary argued that it would be contrary to his duties as a ministerial custodian of state record that's bound to preserve them to...
Well, aren't we just playing games at this point? I mean, if we uphold the statute, we uphold the statute. If we strike it down, we strike it down. I mean, aren't we just playing a game of semantics with that whole second issue?
Your Honor, the Secretary would respectfully request that you declare the proviso constitutional and reverse the trial court, and that could be the end of it. And you wouldn't have to reach the issue of expungement. Okay.
You're down to about two and a half minutes.
Yes, Your Honor. Thank you. I'd like to reserve the rest for rebuttal.
Okay.
May it please the Court. Lynn Herm, appearing on behalf of the appellees in this matter. With me at council table are Buddy Jacobs on behalf of the Florida Prosecuting Attorney.
Ms. Herm, can you push the microphone a little bit toward you?
I can. And Nancy Daniels on behalf of the Florida Public Defender Association. This case is not about deference. It's well established that the legislature has broad discretion in adopting appropriations matters. The cases on that are legion. The trial court applied the proper standard. We don't dispute that standard on appeal. That is a given. We understand that.
Okay, well, the bottom line then, if I can read this statute two ways, and I say each are equally reasonable, where does that put us?
We lose. We acknowledge that. You have a duty to uphold an act of the legislature, including a proviso, if it can be harmonized.
Well, then help me, because, I mean, I think all state lawyers up here, we all think policy-wise it would be a great thing if bar dues could be paid for. But, you know, we're not the legislature. And the language that you have here, maintenance of an individual's professional or trade status in any association or organization. Well, I don't like particularly to think of it as trade status. In order to maintain my status in the Florida bar, I need to have my bar dues paid. So why isn't it a reasonable interpretation of that language, that this language prohibition applies to bar dues?
Because you're not giving effect to every word in the statute with that interpretation. You're not giving effect to the language in any association or organization. You're stopping. In fact, the Secretary's lawyer, when quoting this statute and the Attorney General opinion when applying this language, stopped at professional or trade status. It's not the same thing. The statute is talking about status within an association or organization. It uses, that's the only place in the statute.
Well, do I have any status in the bar if I don't pay my bar dues?
Pardon me?
Do I have any status in the bar if I don't pay my bar dues?
Yes, you have a delinquent status, I think.
Okay, I see what you're saying status within the organization, but why can't that be also the of having some status in the organization whatsoever?
Because it has to mean something. That language has to mean something. Also, the reading of the Attorney General opinions essentially eviscerates the first sentence in paragraph 2. Paragraph 2, the first sentence of paragraph 2 expressly authorizes payment of individual membership dues when there's no institutional memberships available. But the Attorney General opinions would say the only way you can pay individual membership dues is...
What about the Florida Prosecuting Association? Isn't that individual prosecutors association? Aren't there individual memberships to that?
Yes.
And isn't that what the Attorney General said that first sentence was all about?
Well, that is one organization that an Attorney General opinion has concluded might fall within the scope of the statute. But what else is left? There really is almost nothing left when you're talking about professional organizations where membership is required in order to carry out the agency functions. There's almost nothing left. So you're reading out. You can't read paragraph 2, the two
Well, isn't that
sentences.
giving broad, as long as we're not talking about maintaining your status in an organization, doesn't that give broad discretion to the agency head to determine what agencies are appropriate? That first sentence? I know we've only talked about Florida Prosecuting Association, but is there a National Prosecutors Association? Is there, for various other things?
Well, I think that's exactly the problem, is that we don't know what the Attorney General meant with professional or trade status. If you look at that opinion from 1977, there's a very cursory, perfunctory citation of the language that because Florida Bar membership is a precondition to practicing, then membership dues could not be paid from public funds, since the purpose of the membership would be to maintain an individual's
How about the Governmental Bar Association of the Bar? I'm start going somewhere else. I don't look upon the Governmental Bar Association as being necessary for me to maintain my professional status.
It's also probably not necessary. Membership isn't necessary to carry out the
But why couldn't
statutory duties.
Mr. Jacobs' various individual state attorneys say it is necessary? Don't they have that discretion under the statute?
Well, again, I think that's the problem, is that interpretation is completely undefined and unclear, whereas the interpretation that gives effect to all of the words in the statute and reads all of the sections together is a more meaningful, is an interpretation that still allows some meaning for the statute and still allows payment of individual membership dues when institutional memberships are not available.
Okay, if this statute wasn't on the books at all, could your clients pay the bar dues of their individual members?
With or without a proviso? With the proviso that
No,
it's been in
without
effect.
a proviso. If none of this was on the books.
Well, I think that there's language in the Attorney General opinions that suggests no, because there needs to be an express authorization. I'm not an expert on, appropriations law, or agency appropriations, so I don't really know. It seems like it would fall within the category of salaries and benefits that the legislature appropriates every year. So I don't think, certainly in light of the statute, those provisos for the last 10 years have not been necessary. But the provisos, let's talk about those. That's another consideration, if you're trying to harmonize everything, the statute and the provisos and all of the legislative statements on this subject, the provisos allowing payment of bar dues for the last at least 10 years have to mean, the more reasonable interpretation of them is to mean that the legislature did intend for payment of bar dues.
But under your interpretation, that would have been unnecessary.
I do believe that it was unnecessary. However, the provisos did go beyond the language in the statute, and they allowed for payment of...
And under their reading of the statute, arguably those provisos were all illegal.
That's correct.
You just said something that caught my attention. If I heard you correctly, I thought I heard you to say that your, meaning your client's, interpretation of the statute is the more reasonable interpretation. Does it matter whether it's more or less reasonable? Didn't you tell us you lose if there's another reasonable explanation?
As soon as I heard those words come out of my mouth, I tried to backtrack from them, Your Honor, and you caught me.
Okay.
And I
so
agree.
You're going to say never mind now.
Yes. Again, I think our interpretation is necessary to give effect to the language of the statute.
Okay. Now, we'll let you have a bye on that. Tell me again so that I can understand how you reconcile the first and second sentences of subsection 2.
Okay. The first sentence expressly allows payment of individual membership dues when no institutional memberships are available.
Okay.
The second sentence would allow payment of individual membership dues for a higher level of membership. Not just membership, but membership to maintain an individual's professional or trade status only when the individual membership is more economical than an institutional membership.
Well, okay. And maybe I shouldn't be asking you this question. Maybe I should be asking Ms. Davis this question because I think you're probably going to find my question is potentially helpful to your side. This second sentence, it seems to me, reading it as a layman might read it, although it's as is typical of most legislative writing, it's stilted and largely incomprehensible. But reading it as a layman, it seems to me that the second sentence is talking about only situations where agencies can be members, but individual memberships would be more economical. And therefore, it has absolutely nothing whatsoever to do with the first sentence.
And where would you put the individual's professional or trade status in that equation? We have to give effect to that.
I think it's talking about the same thing that sentence 1 is talking about. It's just using different words. I mean, we assume when the legislature uses different words, they mean something different. But that's not always the case. And in fact, it's frequently not the case. I mean, I find your interpretation more strained than the because if the second sentence is meant only to apply when agencies can't be members, then why does it say when purchase of an individual membership is more economical? I mean, that's what Judge Wolf was asking Ms. Davis. More economical than what?
Right.
The then what has to be than an agency membership.
Right. And that's obviously not the way we read it, but I
So you don't want my help. Never mind.
I think, again, approaching this as a purely statutory construction question, we see...
Isn't that what it is?
Yes. No, I agree with that. But we see the need to read some meaning into that language. But if you get us to the same place, that's...
I guess part of my question is about the What happens if there's no statute? Goes to, what if I say this is so messed up that I have no idea what it means? Which is real appealing to me at this point, let me tell you. This is some of the most convoluted wording I've ever seen in my life.
Well, we have to look to the source and explanation of Article 3, Section 12, and that's Brown versus Firestone. And Brown versus Firestone says not only does an appropriations bill prohibited from altering existing substantive law, but it also, any proviso that the legislature puts in the appropriations bill must relate so directly to the appropriation that it must be a purpose for the appropriation. It must be a cause. It must.
I understand that, but doesn't the legislature have the prerogative in an appropriations bill saying money can't be spent for a particular purpose unless you're changing some kind of policy out there? We had the case where they were talking about the not expending funds for those agencies that are proponents of marriage, sex outside of marriage. And clearly that was, a policy thing that they were trying to get to. Here, is there any policy that they're trying to get to, or are they just saying we do not want to spend our money on this particular item?
Well, it absolutely is policy. I mean, every decision about how money is spent relates to policy. And the proviso in Brown versus Firestone that the court struck had to do with the approval for spending emergency funds. And the proviso at issue in the Childs versus Milligan case was the formula for funding of public schools. And so, yes, of course, any decision the legislature makes relates to policy.
Well, the reason it's unconstitutional is because it contradicts a statutory policy.
Well, that's
correct?
one reason. The second reason is because the proviso can't be viewed as a motivating factor for the $5 billion appropriation for salaries and benefits for state employees. What the legislature does when it puts these provisos that relate to expenditure of the funds that only relate to a very small portion of the funds is they make that appropriation or the appropriation decision immune from veto. And that's what Brown versus Firestone tells us the legislature cannot do. So
what if they said the money in this category should only be used for base salary, pension benefits, health benefits, and nothing else? Would that be illegal?
I suspect that there would be substantive laws that would be inconstitutional.
But I'd have to be able to point to some substantive law that it would be changing, right?
In that, again, the test is whether the restriction, the proviso that you've described, can be viewed as a motivating factor behind the appropriation. So in that instance, I think maybe that would be permissible.
How much weight should we give to the argument that, there's an Attorney General opinion, then another Attorney General with another Attorney General opinion, then yet again another Attorney General, and the legislature was aware of this and they didn't, do something to rein in these Attorneys General?
We would ask that you actually look at the Attorney General opinions, and you'll see that there is one sentence in one Attorney General opinion in 1977 that actually even refers to a 1972 decision, which was or opinion, which was issued before the statute came into effect, and it was issued on policy grounds. The subsequent Attorney General opinions only repeat that and don't provide any additional analysis. I see that I'm out of time. We respectfully request that you affirm the judgment of the trial court, which would lift the automatic stay that's in place and allow the agency heads to use their discretion to pay bar dues out of their allocated funds in this fiscal year. Thank you.
Thank you.
Your Honors, if the statute didn't exist or it's ambiguous, then the proviso stands. And also to touch upon some of your questions, to violate Article 3, Section 12, the policy inserted into an appropriations bill that would violate the Constitution and avoid the governor's veto power, which is the purpose of Article 3, Section 12, has to be like those struck in the cases cited in the briefs, like reducing inmate population, reducing class size, making policy decisions on sex between unmarried persons, Medicaid benefits, and the education of welfare recipients. There is no other legislative objective that appellees have pointed to that isn't precisely on the topic of appropriations or the matters related thereto that they concede is within the legislature's authority to provide.
Ms. Davis, let me ask you the same question I asked Ms. Hearn.
Absolutely.
Reconcile the first and second sentences of subsection 2 for me, please.
Yes, Your Honor. I think you were correct when you said the second sentence is separate from the first. The second sentence deals only in instances where the agency membership is available and necessary, as the sentence says, but individual membership happens to be more economical.
Then why is it in the same subsection as the first sentence?
Sure, Your Honor. The first subsection is the broad purpose of the statute to provide agencies to be able to pay dues for their membership.
Well, I thought that was what subsection 1 does.
Subsection 1, yes, Your Honor. That's subsection 1.
Okay. What?
Subsection 2, the first sentence is a narrow exception to that. When the institutional membership isn't available, the individual membership dues may be paid. The second sentence is a prohibition that gives a boundary to the first sentence and also provides an exception when...
Well, it has nothing to do with the first sentence.
That's my problem with the except as, it's more economical. How can it have anything to do with the first sentence?
Your Honor, the beginning of the second sentence starts with however. It's putting a boundary on the first sentence.
But the first sentence talks about only situations where agency membership is not available. The second sentence is clearly talking about only situations when agency membership is available, but individual memberships are more economical. Is that not correct?
Your Honor, if it's ambiguous, the proviso stands.
Okay.
And to make the Secretary...
I take that as a yes. Thank you.
That's probably the best answer you can give to that.
Yes, Your Honor.
And your time is run. I'll give you 15 seconds.
The Secretary respectfully requests that this Court reverse the lower court's order declaring the proviso unconstitutional. Thank you.
Thank you.